It's officially 9 o'clock now, so good morning and welcome to a session of oral arguments before the 5th District Court of Appeal. This is being streamed on YouTube as well. We have two cases this morning. If anybody is watching and hoping to see the Lang versus Lang case at 11 o'clock, oral argument has been dispensed with. The 10 o'clock case will be dealt with separately, starting at 10 o'clock. And right now we have case number 20-632, Herbert Leon Manago Jr. versus the state of Florida. We will have, as a default, 5 minutes for rebuttal. If counsel for appellant wishes anything other than 5 minutes, please let us know at the outset of your argument and we can adjust the time accordingly. And we've got Judge Traver, Judge Eisnagel, and I'm Judge Edwards, as you can see by the tiny little letters under my name. Without any further ado, we will have counsel for appellant proceed.
Good morning, may it please the court. My name is Matthew McLean. I represent the appellant Herbert Manago. I'd like to reserve the 5 minutes for rebuttal that's been previously noted. This is a juvenile resentencing case. It involves the application of statute 775.082, 1B1 and 1B2. The difference between the two subsections is if the defendant actually intended to kill, or attempted to kill the victim, there would be an increased penalty of a 40-year minimum mandatory up to life in prison. It would also affect his judicial review period from being 25 years instead of 15 years. This factor of increased sentence has led to decisions such as Williams versus State in the Florida Supreme Court. In Williams, the Florida Supreme Court said the fact that a defendant intended to kill, or attempted to kill the victim must be found by the jury to impose the increased sentence. In this case, the jury found, or the judge found, that the jury rendered a verdict for felony murder, and the state also proceeded under principal theory. Based off the limited findings, the court noted there was no finding.
We've read the briefs. What's your best argument for reversal?
The best argument for reversal is the court knowingly proceeded under harmless error analysis. This was inappropriate. Harmless error analysis is reserved for appellate courts.
That's the first argument you raised in your brief, right?
That's correct.
I didn't see a response from the state to that argument at all. Did I miss it?
No, it's not there. It doesn't exist. The state did not address that argument in their answer brief. And interestingly,
counsel, I guess my question on that one is, what was that? And maybe it was preserved, but was this argument preserved in the trial court? Did somebody tell the trial judge, you're not allowed to engage in a harmless error analysis? That's only for appellate courts.
Not in those exact terms. I do believe that in the pre-hearing memorandum, the attorney argued to the court that the state cannot, in a post hoc proceeding, try to convince the court that something that the jury did not find by itself. Also, during its closing argument, the defense attorney again argues that sentencing Mr. Manago under 1B1 is foreclosed based off the lack of a jury finding. So while there was no, you cannot proceed under harmless error analysis in those exact terms, the argument was certainly made to the court that it's foreclosed from finding under 1B1.
Let me ask you this: the specific argument that you can't engage in a harmless error analysis at the trial court level, did that need to be preserved? Other than the argument you just made, which is that generally you sort of made the argument. Let's say we don't buy that. Let's say we don't think that's specific enough to preserve the argument that the trial court cannot engage in a harmless error analysis. Did this need to be preserved, or can you make a case that it's fundamental error?
I mean, certainly it's fundamental error. There's nothing more elementary than not knowingly committing an error to then go ahead and find your error to be harmless. And that's cited by the the federal court that we cited in the brief. A court is presumed to know the law and to follow the law. And here there's no precedent for the trial court to engage in a harmless error analysis. That simply was not something that was explained in Williams. That was specifically talking about.
I mean, in this case, the trial court made it very clear that it knew the law. This isn't a question where the trial court just didn't understand the law or wasn't aware of the law or just made an error in its understanding. The trial court said on the record that it understood the law, but it engaged in a harmless error analysis, right, in order to essentially say that it could go ahead and render this sentence.
Yes, and in any situation, that has to be fundamental error. There's nothing greater of an error that could have occurred. Saying that you recognize that there is no jury finding to support that sort of sentencing enhancement, and no error had occurred until the sentencing court actually increased his sentence under 1B1. So just because—
Counsel, let me ask you this way. What would have happened if the trial judge had not engaged in a harmless error analysis? Let's say for a moment that let's assume for the moment that we agree that the trial court cannot engage in a harmless error analysis. And then let's ask the question, what would have happened had the trial court done everything that it did except for it didn't engage in the harmless error analysis?
Well, Manago wouldn't have been, we don't know what his sentence would have been, because the court, I think, would have been prohibited from making its subsequent finding that he intentionally killed the victim. So I think that is an error as well. But
would the sentence have been different?
I don't know what the sentence would have been. It certainly would have been different because there would have been no 40-year minimum mandatory. The judicial review would have been after 15 years.
At least those things would have been different, right?
Certainly, without question. Without question, whether he would have imposed a life sentence with the 15-year review, I don't know the answer to that question. That would be speculating on my part. But certainly, Mr. Manago has served over 15 years, so he would already be entitled to his judicial review at this very moment, had the court correctly found that it could not sentence him under Section 1B1. So that's our initial argument, is that you can't knowingly commit error and then find your own error to be harmless. Aside from that—
Let me ask you this about the remedy. You cited as supplemental authority the 3rd District's opinion, very recent opinion in Green versus State, in which they basically adopt the more recent remedy in from Gaiman, where they send it back for resentencing, or if the state wishes, to impanel a jury to ask the specific question. I mean, in the Aileen case, the elements of the crime already existed at the time of trial in terms of brandishing versus merely carrying. Here, the 3-factor analysis didn't exist at the time your client committed his crime. Should we, or are we able to ignore the clear language of Williams and go along with Green in saying that the state may request a jury be impaneled?
Well, the Green case was cited for 3 purposes. The first one was to note that the court emphasized the harmless error analysis is not appropriate for a trial court to employ. It also stands for the proposition that the error is not harmless, even if it were to be reviewed. And then third, as far as the remedy goes, Green is certainly an outlier. Williams made clear in their decision that the proper remedy under this very specific context is to remand for sentencing under Section 1B2. This court's precedent, its own precedent, follows a similar path. Green is a departure from established precedent from the Florida Supreme Court and from this court. So I'd ask the court not to go ahead and follow in line with Green. And
your desired remedy places us in conflict with Green, does it not?
It would place in conflict with Green, correct.
I have another question about your desired remedy. You're asking that the case be remanded for resentencing in front of a different trial judge. we have seen that body of case law expand somewhat over the last few years, but most of the time that we see remands for resentencing in front of a different judge, it is because that trial judge has entertained at least arguably unconstitutionally inadmissible factors. Where in the record does it show that this particular trial judge did not apply the factors that were statutorily outlined in Section 921?
So it certainly, factor A and F talk about the nature and role in the offense. So that's something to be considered, but you have to be limited by jury findings. And I believe the Shelko case is a perfect example. In Shelko, the defendant was convicted of possession of methamphetamine, yet the court made its own determination that this methamphetamine was a such cartel quality drug that it had to be a trafficking offense, and made a determination that it was sentencing him based off its belief that this was such high quality methamphetamine that he should somehow be considered a drug trafficker. So in this case, the court's limited to jury findings as regard to factors A and F to determine his role in the offense. And what the jury found was that he's convicted of felony murder, not premeditated murder, not an intentional killing, but
you're viewing those factors A and F as being a legal finding as opposed to a factual finding. So in other words, isn't one way to look at A and F is to just simply say what factually was the role of the defendant in the committed crime?
Certainly, it's a factual finding, but it's limited by legal principles. So if you had somebody convicted of manslaughter, you couldn't then therefore say he intentionally killed the victim. You're limited by, even though the judge might believe that, you're limited by the fact that the jury found a specific finding. So had it been a premeditated murder finding, then you could make the finding of fact that this was an intentional killing. But if you go beyond what the jury's finding under factors A and F, then it's an improper factor to be considered in sentencing. And since this court made that finding, then we have to remand before a different judge, because we don't know that the jury didn't find his role in the case. And so going back to the game and decision, which is what was relied upon in Green, that had to do with a finding of whether a defendant was a danger to community in the sentencing context. It's a lot different than an element of the offense. The Florida Supreme Court made it more akin to the death penalty argument, where there's bifurcated proceedings with guilt phase and penalty phase. And I think under that specific context, which the Green Court has now used this line of cases under, it just does not follow. In a danger of the community finding, you would have a separate proceeding that would not be presented to a jury until after a verdict is reached. So there would be a similar bifurcated proceeding to the death penalty proceeding. But
the problem I have, going all the way back to Aileen versus U.S., in that particular case, the sentencing distinction existed at the time of trial. In other words, the government at that point in Aileen could have proved specifically and asked for a jury verdict, a specific interrogatory jury verdict. Was he merely carrying the weapon or brandishing the weapon? In your client's case, this distinction with the three different factors really didn't exist until 2014, long after the trial and long after the crime, correct?
That's correct.
So to characterize it as an element of the offense back then, it is, I understand why the Supreme Court uses that language in Williams, because it does increase or elevate the severity of the sentence by changing the floor, but it's not truly an element of the crime back at the time of trial. Why isn't the state entitled to present that question, which has never been presented to the jury before, so that the jury can answer their question in according with Aileen? In other words, a jury determines that fact.
Well, I guess I have two responses for that. The first, we're bound by precedent, and this wasn't briefed as well. I do know the Florida Supreme Court in Williams said this would open a gamut of double jeopardy issues that did not want to get into with the Williams decision. And then this
says it's not is a dodge.
It's a dodge, but it recognizes that there are significant issues that would come into play if that remedy were to have been provided. And so they avoided, by constitutional avoidance, the issue. The second point is the state never asked to impanel a jury. So they didn't ask for it at the trial court. They didn't ask for it on appeal. So the remedy, I believe, is waived at this point, and the argument should not be addressed. Their argument on appeal is that there was harmless error that occurred in this case. It wasn't if this court finds that the error was harmful, that the remedy should be remand with the jury. They never made that argument, so I believe it's foreclosed from this proceeding.
All right, then you're right at your rebuttal time. You want to save the rest of it?
Yes, I'll go ahead and reserve the rest. Thank you.
Right. Then we will turn to the appellee state of Florida.
May it please the court. My name is Bonnie Parrish. I represent the state of Florida in this case. It's the state's position that any error that occurred in the trial judge resentencing Mr. Manago in this case is harmless. And while I recognize that the judge in his order talked about applying applying harmless error, if you take that out of his order, the law that he set forth, he did exactly what he's supposed to do for resentencing. He considered the trial transcript. He had a resentencing hearing. He did everything that he was supposed to do. And based
without the harmless error analysis, the sentence would have been different, correct?
I don't believe so, no, because he was not the judge who presided at the trial. This trial took place 15 years ago. He was not the judge who presided at trial. He, in order to resentence this defendant, he had to go through that record, the trial transcript, look at all of those facts to determine what kind of sentence he would impose.
What does that have to do with the minimum 40 years and the Elaine violation?
Well,
what does that have to do with the fact the jury didn't make the finding?
Well, the jury didn't make the finding because they weren't required to make the finding then.
Right.
That's why there's
but they didn't.
Exactly. Yes, there was no finding.
So without the harmless error analysis, you're telling me that this sentence could have been exactly the same?
Yes, I believe he could have, based on the record that was before him, based on what was presented at the resentencing hearing and the trial transcript, that he could have imposed that sentence again.
So
yes.
There's no Elaine violation at all?
No, I'm not saying there was no Elaine violation. I'm not saying that. But I'm saying that he could, his review of the record, his determination about the facts, what occurred during that trial, the evidence that was introduced at that trial, that's what he based his sentencing determination on.
What would it have mattered if it was the same judge under that analysis? So say that this particular trial judge 15 years ago had tried this case. Are you saying that then he could not have done a harmless error analysis?
Well, no, I'm not saying that. He could have certainly found those facts as the presiding judge. Yes.
Can you give me a single other instance in which a trial court can act as its own reviewing body other than?
No, no, sir. I'm certainly not arguing that that's what he should be allowed to do. But I think it's sort of a semantical use of the word when he talks about harmless error. He's citing the case. He clearly did research, understood what he was supposed to do, and he set forth the law in there. And
I don't doubt for a second he needed to re-review the transcript to conduct a sentencing hearing under Section 921. I guess I'll ask Judge Eisnagel's question in a slightly different way. Why wasn't the trial court bound by the Williams Florida Supreme Court case?
I think he was bound by Williams, but I don't think Williams.
Is the holding of Williams that if there is an Elaine error, that there must be a resentencing under 1B2?
unless the evidence at trial established that a reasonable jury could have found
Counsel,
beyond.
that's the harmless error analysis that you're talking about now. You are now describing to us the harmless error analysis, are you not?
Yes.
Okay,
Yes, I am.
So when I asked you if the trial judge would have rendered the same sentence without the harmless error analysis, you said yes, but now you agree that's not true.
I think I honestly, I don't know what he would have done.
Well, counsel,
But
how could he
I-
possibly have sentenced under B1 without the harmless error analysis? Explain that to us.
Well,
I think you've lost us.
I guess he couldn't have.
Okay.
There had to be a finding that
Right.
he actually killed.
So now you agree the sentence would have necessarily been different had the trial judge not engaged in the harmless error analysis, correct?
Correct.
B1 versus, yes. Okay.
But go ahead, I'm sorry.
When you want to engage in a fundamental error analysis for us on this, in case we determine, I mean, do you think that, well, let's talk about that. Maybe you think that a trial court can engage in a harmless error analysis.
I don't think a trial court can determine that what they do is going to be harmless. I don't agree with that. No. But I just.
It seems like your only argument then, the only argument that you could now, that given these concessions, the only way you can prevail in this appeal is if the argument was not preserved and it is not fundamental error.
Well, it wasn't made below, so it would not be preserved.
Fundamental
Wasn't
error.
there a motion? Wasn't there a motion? Sorry, Judge Eisnagel. Was there a motion that was filed asking the court to impose 1B2 or 2B2 precisely because Williams was binding?
Yes, and they also asked to find 1B1 unconstitutional. Yes,
I mean,
they did file that.
let alone the first part, because it's unnecessary if you follow Williams, right? I mean, isn't the argument preserved just by saying, hey, Judge, you're bound by Williams, so you have to sentence under 2B2?
Well, I mean, they didn't argue that he couldn't do the harmless error analysis that he did.
Which counsel is in Williams, right? The harmless error analysis in Williams.
Yes, it is. It is. So
I mean, they also didn't argue that they couldn't put him to death. I mean, I don't necessarily know, and I'm saying that probably unnecessarily provocatively, but I don't necessarily know, does preservation stand for the proposition that you have to tell a judge that they have to follow the law and precisely how they have to follow it?
I don't believe exactly that, but if there is a problem with it, they need to object so the judge has the opportunity. He could have corrected it. He could have said, you know what, you're right, I can't do that. He could have fixed it then.
Remind me, counsel, and maybe both attorneys should address this, but when did this error, assuming that it is error, it seems like it might well be, when did this error first appear?
In this case?
I can't remember. Did the trial judge engage in the harmless error analysis at the hearing?
No, he did it in his written order.
Right.
Which was after the hearing.
So this would be the type of error that should be preserved in a motion, in a motion after the order, right? After the sentence comes out.
Or an objection during the sentencing hearing. An objection could have been made when he gave everybody the
objection
order.
when the trial judge doesn't engage in the harmless error analysis at the hearing.
Well, he provided the order to everybody. So, I mean, it was in there, but yes, they could have done a motion for rehearing something after the fact too.
But is it fundamental error? I mean, it seems like that there is no doubt, absolutely no doubt, that the sentence would be materially different without the harmless error analysis below.
You probably are correct on that.
So is that,
I would
walk me through, is that not fundamental error? I mean, if we can say 100% the sentence would be reduced without this error.
It's a hard thing for me to say.
Right.
I mean, he had two ways he could have sentenced: under 1B1, which is what he did, or under 1B2, which is what he didn't. 25 years versus 15 years. He could still impose the life sentence. He just gets review 10 years earlier. I mean, that's really what this comes down to. If this court determines that it was fundamental error, then based on Williams, the remedy would be he goes back and is sentenced under 1B2. That does not mean that he can't be sentenced to life. And I don't believe a review of this record, there's anything that indicates a new judge should be appointed to resentence him. The judge did not make any comments that he relied on improper factors. There's nothing to show that he did anything improper in reaching this decision.
Well, it seems like a lot of that flows from the trial court's, arguable error of engaging in its own harmless error analysis and making the finding itself essentially through the harmless error analysis, right?
But that finding was based on the record, based on the trial transcript, the evidence that was introduced at trial.
I'm just saying it seems like a lot of the other arguments that the appellant raises flow from, in some way or another, from that harmless error analysis.
Yes, I would agree with that.
I mean, in other words, I'm not sure that there's anything in the record that demonstrates any bias or prejudice or ill will, anything improper from the trial judge, other than just the trial judge erred potentially.
Absolutely, I would agree with that. There's nothing. He didn't consider factors that he shouldn't consider. He didn't consider the commission of other crimes that he shouldn't have. He didn't consider anything that he shouldn't consider. He engaged in his own harmless error analysis of his own ruling. That's all that he did. I don't think that requires a new judge to resentence him.
In terms of the remedy, you agree that the remedy is resentencing, unlike what the third DCA discussed in Green?
I do. I believe Williams sets that out pretty well. It does appear in, I think it's Cologne, there are some comments by a couple of the justices that the remedy wasn't really discussed as much in Williams, and that maybe it should come up at a later time and really address whether it should just be for resentencing, whether it should be remand for a jury. Honestly, this case is 15 years old. I find it hard to believe that they would decide to impanel a jury on this. I could be wrong about that, but
that's kind of not really within our jurisdiction, right? To decide
I realize that.
But maybe the third DCA is right, but aren't we bound by Williams? Even if the third DCA has the better view of what the law should be, aren't we bound by Williams?
I believe that we are, yes. It's the Florida Supreme Court. The third DCA is the third DCA.
Do you have anything more for us, or shall we go back to the appellant?
I don't, unless you have any other questions for me. I would ask that you affirm. Thank you.
None, we're back to Mr. McLean.
Thank you. May it please the court. I don't have anything really further to add unless there's any specific questions the court has for me. Again, we're asking for the court to find error in this case, in this resentencing, to go ahead and remand for resentencing under Section 1B2 and have that done for a different judge. If there are no further questions, I'll go ahead and rest.
Any further questions? All right, we're done. Thank you very much. And we are in recess.
Thank you.